pleases this Honourable Court, my Lord and Lady Assessors, to hear the matter of State versus Moses Mpofu and Mike Chimombe.
Thank you.
If you may please the Honourable Court, my name is W. Mabauda. I appear for the State in this matter.
Thank you.
May I please this Honourable Court, my Lord and Learned Assessors, TST Dretero is my name. I appear with Mr. J. Koto on behalf of the first accused person in this matter.
Thank you.
The court is pleased, my Lord. My Learned Assessors, GRJ Story with Mr. M. Giawi, to appear for the second accused person.
Yes, thank you.
My Lord, the matter is coming for judgment.
Thank you. Can you please open the doors, the two doors, just to allow in more air? Very well. This is the judgment of the court in the case of the State versus Moses Mpofu and Mike Chimombe. I must say that this judgment is extracted from my notebook and typed by the secretaries. It may have typos here and there, which may eventually be cleaned depending on the and the final judgment will be uploaded on ICMS when we finally upload it, depending on the verdict. If the verdict is that of not guilty, then that will be the end. It will just clean it and upload it. But if the verdict is that of guilty, then the uploading of the judgment will await the final completion of the matter. I therefore urge all parties, all interested parties, to take notes of what I will be reading, because at the moment this is just extempore. The judgment is long. This trial took a lot of time to complete, a long time to complete. The submissions by the parties were very detailed and very long. The evidence is also long. So, but I'm required by law to read the judgment fully in an open court. I will not therefore read just the operative part. I will read everything that is contained in the judgment. The accused persons are jointly charged with fraud, a crime defined in Section 136 of the Criminal Law Codification and Reform Act, Chapter 923, which shall be referred to later on as the Criminal Law Code. The charges set out by the state in the indictment can be paraphrased as follows. Sometime during the period extending from the 3rd of September 2021 to 29 August 2022 in Harare, the accused persons acted in contact and with common purpose and with intent to deceive the Ministry of Agriculture, Water, Fisheries and Rural Development, or realizing that there was a real risk or possibility of deceiving the ministry and intending the ministry to act on the misrepresentation to the prejudice of the state. Made the following misrepresentations: that Black Duck livestock and poultry farming was a company registered in terms of the laws of Zimbabwe. B, that a Zimra tax clearance certificate bearing business partner number 020100158956 was genuine and had been validly issued to Black Duck livestock and poultry farming by the Zimbabwe Revenue Authority for the period covered by this charge. Or that a compliance certificate with NASA registration number 0197190L had been validly issued to Black Duck livestock poultry farming by the National Social Security Authority. And whereas when the accused persons made the misrepresentations, they knew that Black Deck Livestock Poultry Farming was not registered as a company in terms of the laws of Zimbabwe, and that the tax clearance and the NASA compliance certificates were not authentic, then thus knowing that Black Deck Livestock and Poultry Farming was not eligible to submit a valid bid for the tender to supply to the state 632 and 1 goats under the Presidential Goats Pass-on Scheme, which was being administered by the ministry on behalf of the state, and that Black Deck Livestock and Poultry Farming had no capacity to supply the goats. The ministry was deceived into believing that Black Deck Livestock Poultry Farming was a registered company and that the bid submitted by it was valid, and that Black Deck Livestock Poultry Farming had the required capacity to supply the goats. And whereupon the ministry awarded the tender to the company and paid the sum of 1.6 billion Zimbabwe dollars, which was equivalent to 7,712,197 and United States dollars and 10 cents. So that is the charge which the accused persons are facing. The state summarized its case as follows. The first accused is aged, or was then aged 49 years and resides in Greendale. He is the managing director of Black Deck Private Limited. Accused 2 is aged 43 years, or was then when the trial started, and resides in Borodale. Sometime in 2021, the government introduced the Presidential Goat Pass-on Scheme as part of the rural development agenda, targeting to alleviate poverty among less privileged households across the country's 10 provinces. The government had targeted to buy special goat breeds for households and village herds, and anticipated to procure more than 500,000 goats for this scheme. The Ministry of Lands, Agriculture, Water, Fisheries and Rural Development, I will refer to it later as the Ministry of Lands, was mandated by the government to implement the program. As a result, on the 3rd of September 2021, the ministry flighted a tender for the supply of the delivered goods under that scheme, which was closing on the 17th of September 2021. 4 companies, namely Coltram Enterprises Private Limited, Black Deck Livestock and Poultry Farming, Militech Enterprises Private Limited, and Chimombe Farms Private Limited, responded to the tender by submitting bids to the ministry. Pursuant to their plan to defraud the, that is the state allegation, that pursuant to their plan to defraud the government of Zimbabwe of its money, the accused persons acting in connivance and well knowing that Black Deck Livestock Poultry Farming was not registered and that it did not have a valid ZIMRA clearance certificate and the NASA compliance certificate, which were required for the eligibility to submit a bid, forged a ZIMRA tax clearance certificate and the compliance certificates already discussed above, and attached those documents to the bidding documents that were submitted to the ministry. Investigations conducted by NASA indicated that the QR code and the reference number on the compliance certificate used in the bidding process had been issued to Skywalk Investments, whose registration number is 0196793N. It was further established that Black Deck Private Limited, which appeared on the compliance certificate as the company to which the compliance certificate had been issued, had been deregistered from the NASA system on with effective the 8th of January 2016. investigations carried out by Zimra established that Black Deck Private Limited was never issued with a Zimra tax clearance certificate for the year 2021, and that the QR code on the forged tax clearance certificate belonged to Skywalk Investments. Investigations also established that the company Black Deck, the purported company Black Deck Livestock and Poultry Farming, did not exist, and the Ministry of Lands, believing that what had been presented to it was genuine, went on to award the contract as aforementioned. On the 16th of November 2021, the Ministry of Lands entered into a contract with Black Deck Livestock Poultry Farming for the supply and the delivery of 632,001 goat for the Presidential Goats Pass-on Scheme, and they were valued at, and the value was stated in the contract as 87,757,168 United States dollars, and the first accused person signed the contract on behalf of Black Deck Livestock Poultry Farming, and one Tinashe Chimombe signed as a witness. In clause 29(1) of the contract, the ministry had agreed to make payment, an advance payment of 30% to Black Deck Livestock and Poultry Farming. The accused persons, in an effort to convince the Ministry of Lands to make advance payment, attended meetings with ministry officials, misrepresenting that they had several goats stocked at their holding sites. The ministry, believing that the accused persons had presented it was true, transferred Zimbabwe dollars equivalent, Zimbabwe dollar 901,294,000. Wait a minute. 901,294,200 the Zimbabwean currency into the account held by Black Deck in its Caps Bank account number provided, and this deposit was made on the 22nd of April 2022. On the 23rd of April 2022, the first accused person transferred 100 million from that money which had been paid to the second accused person's company bank account, namely Militech Enterprises, and account number provided. Subsequently, on the 26th of April, another amount of 100 million was transferred into Militech Enterprises bank account. On the 29th of June 2022, the ministry made another payment of 698,705,800 Zimbabwe dollars into the Black Deck Caps account, which brought the total amount disbursed by the ministry to 1.6 billion, which, according to the state, was equivalent to 7,712,197,000. I'll take that again. 7,712,197 United States dollars. This was at the prevailing interbank rates. Following delays in the delivery of the goods, the Ministry of Lands officials made several arrangements with the two accused persons demanding delivery, and the accused persons, in an effort to further deceive and convince the Ministry of officials, went to generate and present to the Ministry of Lands holding site schedule, where they misrepresented that they were holding 32,500 goats mobilized across the provinces, which were ready for distribution to final beneficiaries. The Ministry of Lands then deployed teams to verify the claim. The result of the verification exercise was that the ministry found out that the accused persons had only 3,713 goats as opposed to the 32,500 goats claimed by them. The ministry then eventually cancelled the agreement when it was clear that it was being deceived by the accused persons. All in all, the accused persons only managed to deliver 4,208 goats valued at 331,445.25 United States dollars from the 7,712,197.10 which had been paid, United States, which had been paid by the ministry. And the state alleges that the rest was misappropriated by the accused persons. Both accused persons denied the charge. The first accused person in his defense said the following. He denied making any misrepresentation to the ministry, especially the alleged misrepresentation, or doing anything to deceive the ministry, or with the realization that the ministry would be deceived, or with the intention to cause the ministry to act upon any misrepresentation. He denied submitting the alleged documents to the ministry. He denied that he misrepresenting that Black Tech Livestock Poultry and Farming was a registered company with a valid clearance tax and valid NASA compliance. He denied personally submitting a bid to the ministry as alleged by the state. Overall, he denied committing fraud as alleged by the state and put the state to the proof of its allegations. He asserted that the matter before the court was not criminal in nature. He said that the state allegations did not disclose the essential elements of fraud. He said there was nothing criminal in the bid or the nature of the documents supplied with the bid. He said the matter before the court was just a contractual dispute between the Ministry of Lands and Black Tech Private Limited, a company duly registered in Zimbabwe, and that the cancellation of the contract by the ministry in itself showed that this matter is in fact a contractual dispute and not a criminal case. The state has remedies in contract law which it has not exhausted. The state has not made any efforts to recover the money from the guarantor because there was a guarantee submitted by a bank. And resorting to criminal proceedings against their first accused person was wrong, misplaced, and unfounded. Even criminal proceedings against Black Tech Private Limited would not be justified, would certainly be unlawful, and to the best of his knowledge, the name Black Tech Poultry and Farming is a trade name of Black Tech Private Limited. And all the documents submitted with the bid belonged to Black Tech Private Limited, and all payments were made to that company and not to him. He said, although he was a director of Black Tech Private Limited during the period relevant to the charge, he was not the only natural person in control of that company. There were other directors and shareholders who collectively made decisions in the interests of the company. He was thus not solely responsible for everything done by the company and its actions. He was aware that Black Tech Private Limited passed a resolution to submit a bid to supply goats under the presidential scheme. Be that as it may, he did not participate in the compilation and submission of the bid and the supporting documents, which included the allegedly fake ZIMRA and NASA certificates. He said the company outsourced the procurement of the ZIMRA and NASA certificates to an independent tax expert. And the tax expert is the one who processed and furnished the company with the documents. He was never personally the custodian of these documents. He said Black Deck Private Limited had and still has the capacity to supply the required goods, except that the contract was unlawfully terminated by the ministry. He disputed the allegation that the state suffered prejudice. He averred that he was being prosecuted at the behest of a third hand or interested parties who are prosecuting him for political gain. He prayed for his acquittal. He gave notice, that is the first accused person, that he was going to lead evidence from 5 witnesses in his defense. He was going to testify to confirm the defense outline. He was going to call Visimusu Mpofu, who was mandated by Black Deck Private Limited to outsource for the specialists for a specialist for the purpose of complying with the various statutory obligations, including but not limited to the ZIMRA tax clearance and the NASA certificate. The company approached one Kundai Bwanya, a representative of the consultants company, who obtained and processed the ZIMRA tax clearance and NASA certificate. Those were the documents which were submitted to the ministry by the company, believing the same to be true, authentic and genuine. He was aware that Black Deck Poultry Farming was the trading name. The witness would confirm that Black Deck Poultry Farming, livestock and poultry farming is a trading name of Black Deck Private Limited. He said he would call Tichao Nachidembo, who compiled the bid and the documents that were submitted with it on behalf of Black Deck Private Limited. He said he would say that he used documents on file kept in the office to compile the bid. He did so verily believing that all the documents kept in the company files were genuine and authentic. Tichao Nachidembo was going to say that in compiling and submitting the bid, he never showed the bid to the first accused person, and that he never received any documents from the first accused person. He too was going to confirm that Black Deck Poultry, Livestock and Poultry Farming is just a trade name of Black Deck Private Limited. The first accused said he was going to call Hajine Kabisira, who is the director of Black Deck Private Limited, who was going to produce all the company documents, including the certificate of incorporation, Sierra 16, Sierra 5, the memorandums of Sierra 14, memorandum of articles of association, to prove the incorporation of Black Deck Private Limited in terms of the laws of Zimbabwe. She was going to produce all the company's letterheads. She was aware that the company resolved to submit a bid and that the company outsourced through its officials the provision of critical documents and required to meet statutory requirements, which included the ZIMRA tax clearance and NASA compliance certificate. She was going to say that the documents submitted, outsourced, were then submitted by the company which believed that they were genuine. They were never shown to her. They were never shown to the first accused person or any other director of the company. The first accused was going to call a representative of the consulting company without naming the witness. He said the witness would be subpoenaed. The second accused person's defense was as follows. He denied committing the crime in question and more specifically making any the alleged misrepresentation to the ministry. He denied making any misrepresentation regarding the incorporation status of Black Deck Livestock and Poultry Farming. He denied the allegation that he submitted fraudulent ZIMRA and NASA certificates. He denied making any misrepresentation regarding the capacity of Black Deck Livestock and Poultry Farming to supply 632,201 goats He said he was not a party to that contract. He did not see why he was being dragged before the court because there was no evidence linking him with the alleged fraud. He said he had no relationship with Black Dick Private Limited or the alleged unregistered entity. He was not a member or employee or agent or shareholder of either of these entities. He had not at any time acted in any authorized capacity on behalf of Black Dick Private Limited or the alleged unregistered entity as alleged by the state. He averred that the doctrine of common purpose, which the state sought to rely on, did not apply to the circumstance of this case. The state had not shown that he was associated with the forged documents. He had no knowledge of how Black Dick Private Limited had sourced and the documents and prepared his bid. He had no knowledge of the contract between the ministry and Black Dick. He was nowhere near where the agreement was entered into. He was not present when goods were supplied to the ministry by Black Dick Private Limited. He did not receive any money. Obviously, he meant in person. Did not receive any money from Black Dick Private Limited, which was part of the process paid by the ministry. The only time that he, the second accused, recalls is when he attended a meeting at the Ministry of Lands after a dispute had already arisen between Black Dick Private Limited and the ministry. He attended the meeting in his capacity as a chairperson of a local pressure group called EEG, Economic Empowerment Group, which advocates for the prioritization of local companies by government when entering into agreements for the supply of goods and services. The meeting was way after the alleged offense had been committed, and he was simply attending in his capacity to help the parties find each other. The accused would bring, he said he would bring it to the attention of the court that he is a director and shareholder of Militech Enterprises Private Limited, which responded to the tender and submitted a bid and failed. He said, therefore, it would be absurd to expect him that he would have advanced the interests of a competitor, which is Black Dick Private Limited, in preparation of his bid and in negotiating the contract. He will say that Black Dick Private Limited won the bid and thereafter subcontracted Militech Enterprises, among other companies, which he named as Cedar Farming Private Limited and Nomstel Enterprises Private Limited, to secure goods. And the arrangement had nothing to do, was separate rather from the agreement between Black Dick Private Limited and the ministry. He prayed for his acquittal. In terms of Section 186 of the Criminal Procedure and Evidence Act, Chapter 907, all issues raised by the plea, as read with the defense outlines, have to be tried. When the accused persons pleaded not guilty by their plea without any further form, were deemed to have demanded that the issues raised by such plea shall be tried. In terms of Section 18.4 of the Criminal Law Codification Reform Act, which regulates the degree and burden of proof in criminal cases, except where the code or any expressly imposes a burden of proof of a particular fact or circumstance upon the person charged with a crime, once there is evidence before the court which raises a defense to the charge, whether or not the evidence has been introduced by the accused, the burden shall rest upon the prosecution to prove a reasonable doubt, beyond reasonable doubt, that the defense does not apply. I should therefore mention that the statement by the first accused person that the state is put to the proof of its allegations was completely unnecessary, because that is what it is by operation of law. Anyway, in our view, the state was then required to prove the following arising from the charge that it had preferred against the accused persons. That a certain bid to supply goats under the presidential goat scheme was submitted in the name of Black Duck Livestock and Poultry Farming. That the bidder, as described above, was not duly incorporated as a company in terms of the laws of Zimbabwe. That the accused persons acted in concert and in common to submit the bid, and that either by way of misrepresentation, either Zimra's tax clearance certificate submitted with the bid was counterfeit, or the NASA compliance certificate submitted with the bid was counterfeit, or that Black Duck Livestock Poultry Farming had no capacity to supply the goods in terms of the tender awarded to it. We used the word, the article O to show that the alleged misrepresentations, each one of them, if proved, would suffice to constitute fraud. In other words, it would suffice if the state proved that the tax clearance certificate was fake and failed to prove the rest. That would still constitute fraud. The state also needed to prove that the bid submitted by Black Duck Livestock Poultry Farming was tainted by the alleged acts of misrepresentation, whichever was proved, and that the ministry acted on the misrepresentation and treated the bid submitted by Black Duck Livestock as valid when it ought to have been disqualified, and that the misrepresentation brought about potential or actual prejudice, or that the accused persons were each and personally criminally liable to be convicted for the crime that arises from such conduct. Fraud. In order to prove its case, the state called the following evidence from witnesses who testified. Fungai Kafunde told the court that she was employed by Zimra as a supervisor in the taxpayer registration section. He described a tax clearance certificate as a document issued by Zimra to a taxpayer who is up to date with tax payments. It is procured through self-service by a taxpayer logging onto a Zimra portal if the taxpayer's affairs are in order. The Zimra system issues the certificate without any involvement or intervention of Zimra officials. In other words, there would be no human interaction with Zimra officials. It is just generated from a portal. An authentic tax clearance certificate would have a Zimra logo at the top, the tax year, the name of the taxpayer, and a business partner number, and a statement that the taxpayer's position is satisfactory and the expiry date of the certificate. It would have a unique authentication code which would be generated by the system and could not be duplicated. The witness said Zimra was approached by by the Zimbabwe Anti-Corruption Commission hereinafter ZAC, which needed to verify a tax clearance certificate in their possession. He checked the document, which purported on the face of it to have been issued to Black Duck Private Limited, and he did so in the presence of ZAC officials. He concluded that the document was not authentic because he could not find it in the Zimra SAP system. Black Duck Private Limited had not been issued with a taxpayer certificate for the year 2021. The witness identified the fake certificate in court through the name Black Duck Private Limited, which appeared on the face of the document, the BP number, the authentication code, and the QR scanner. He said when scanned, the document revealed that in fact it was originally a certificate issued to Skywalk Investments. What that meant was that the QR code and the verification codes did not belong to Black Duck Private Limited. The witness could not tell how the tax clearance had been altered to appear as if it had been issued to Black Duck Private Limited, but he was adamant that a Zimra certificate could not contain information relating to two companies. The certificate was produced in court as an exhibit. the defense had initially objected to the production of the documents, challenging its authenticity, but later consented to its production after inspecting the original. The witness was subjected to cross-examination by the defense, at the end of which all the witness assertion that the Zimra clearance certificate was counterfeit, in as far as it purported to have been issued to Black Deck Private Limited, remained intact. This witness gave his evidence well. We found him credible, and what it means is that Black Deck Private Limited was not Zimra tax compliant and was not eligible to be issued with the tax clearance. And the use of the counterfeit tax clearance by Black Deck or anyone purporting that it was genuine would, on its own, constitute fraud if the use was accompanied by the requisite knowledge. This is the definition in section 135 of the Criminal Law Code, which says misrepresentation means any act, omission, or of any kind whatsoever, which wrongly or incorrectly represents any fact, law, character, or circumstance, or opinion, or other thing whatsoever, without limiting that definition, includes the use, publication, uttering of a document which contains a false statement, and knowing that the document contains a false statement, or realizing that there is a real risk that it does so. The next witness was Chimombe, who told the court that he was employed by the National Social Security Authority as a National Compliance Manager, Credit Control. He said NASA compliance certificate is issued to confirm that a company is compliant with NASA statutory requirements. The certificate is a requirement in terms of the law, is Statutory Instrument 63 of 2022. A NASA compliance certificate is a mandatory requirement in all government tender processes. All government ministries, departments, and agencies are instructed to include the NASA compliance certificate as part of the mandatory eligibility documents for government contracts. When the company is in compliance, it can generate the NASA compliance certificate from the NASA self-service portal. The certificate has security features. The witness confirmed that he knew Black Deck Private Limited is a company that was previously registered with NASA, but had been registered on the 8th of January 2016 and had been inactive ever since. NASA was approached by ZAC officials to verify the authenticity of a compliance certificate, which was handed to him for the period of year 2021. He confirmed that the certificate was not authentic. The information on the QR code gave the name of the company as Skywalk Investments and did not tally with Black Deck Private Limited, which was the name on the document handed to him by ZAC. There was evidence of tampering with the document. He said a company which is not tax compliant cannot generate a genuine NASA compliance certificate. The alleged counterfeit NASA certificate was produced by the state as Exhibit 2, eventually with the consent of the accused person. On the face of it, it purported to be a compliance certificate issued to Black Deck Private Limited, and all the other features as testified to by the witness were confirmed. The witness was cross-examined by counsel for the first and second accused person. He said, under cross-examination, he said he was not clear as to who would have falsified the compliance certificate. He could not dispute they claim that Black Deck Private Limited outsourced the production of this document, of the certificate. This witness gave his evidence well. He did not seek to color his evidence, to exaggerate it. We found him credible. The gravamen of his testimony remained intact, which was essentially that the certificate handed to him by Zach was counterfeit. What do we make of that evidence? What we make is that the use of the counterfeit NASA compliance certificate by anyone, including Black Deck Private Limited, would therefore on its own constitute fraud if the use was accompanied by the requisite knowledge. I have already referred to the law on this point. John Basera testified that he was the permanent secretary at the ministry at the relevant time. In 2021, the ministry published an advertisement calling for bids to supply goats. 4 companies submitted bids. He named them by short forms of their names as Black Deck, Militech, Chimombe, and Coltram. The tender was part of a government rural development program meant to uplift the livelihood of rural families in areas of the country with low rainfall and areas where livestock was affected by disease during the period extending from 2015 to 2020. Each household was going to get 1 goat to boost household nutrition and financial security. Over 500 goats were supposed to be delivered. Bidders for the tender were supposed to supply to submit bids following the template obtainable from the ministry, which was the standard bidding document. As Zimra clearance and NASA clearance were listed in the standard bidding document as mandatory documents for a valid bid. He said, following an adjudication of the bids and recommendations, I'll take that again. Following adjudication of the bid, recommendations were made to the Procurement Regulatory Authority of Zimbabwe by his ministry, and then there was no objection by PRAZ, that is the abbreviation for Procurement Regulatory Authority of Zimbabwe, to the tender processes and the outcome of the bidding processes, whereupon the ministry signed a contract with Black Deck. During his testimony, he kept referring to the successful bidder as Black Deck. The state produced exhibits through that witness. The government standard bidding document, which was the template to be followed in preparing the bids. Its important feature was that it listed that it preferred the bid to be submitted as a fastened document, spiral bound, with a bid submission sheet, a statement of the requirements, a copy of every document necessary to demonstrate eligibility, a proof of registration with the procurement with PRAZ, a bid security in the format supplied, a CR6, CR14, a copy of the company's certificate of incorporation, a tax clearance, and a clearly stated payment term and delivery period. And he also produced the contract, which describes itself as general conditions for the contract for the supply of delivery goods in the presidential scheme, entered into between the government of the Republic of Zimbabwe and Black Deck Livestock and Poultry Farming on the 16th of, signed on the 16th of November 2021 as Exhibit 4. The first accused person signed the contract on behalf of Black Tech Livestock and Poultry Farming, and the witness, Mr. Basera, John Basera, signed on behalf of the ministry. He also produced the Government Gazette Extraordinary dated 3rd September 2021, the Sunday Mail newspaper extract where the tender was advertised, and a report called a violation of tender by the ministry dated 12 October 2021. The report described itself as a report prepared by the Tender Evaluation Committee, which consisted of C. Garise as chairperson, M. Ruputse as a member, P. Mashiri as a member, P. Mondiwa as a member, and L. Kanengoni as a member. It adjudicated upon the bids submitted by the bidders. The assessment of the bids was based on the administrative, that is what the report says, on the administrative, mandatory, and eligibility and qualification criteria requirements stated in the tender document, which was published. Coltram Enterprises and Militech were disqualified for non-compliance with the tender documents. The committee observed that Chimombe and Black Tech Livestock were compliant with the administrative, mandatory, and eligibility and qualification criteria stated on the tender documents. It then recommended Black Tech Livestock. The name appears as Black Tech Livestock in the report, for the supply of 15,557 Mashona goats, 16,444 Matebele goats, 5,005 Boa goats, 1,798 Kalahari goats, 368.95 Mashona goats, 239.105 Matebele goats. We did not try to do the addition. We just extracted it as it is presented in the report. So the total number would obviously be deciphered from a simple mathematics. He also produced a notification to the Black Tech Private Limited as a winning, Black Tech Private Limited as the winning bidder, as Exhibit 8. This letter was advising it of the award of the tender and the goods to be supplied. He also produced a letter cancelling the contract dated 19 August 2022, addressed to Mr. Moses Mpofu, who is the first accused person. The document was the document which was addressed to Mr. Mpofu was produced by consent in terms of Section 314 of the Criminal Procedure and Evidence Act, which means that its contents were admitted. The contents appear in the record, in the judgment, but it was simply to the effect that the contract was being cancelled. Black Tech Livestock Farming Limited was awarded the tender. It said was awarded the tender. Thereafter, several arrangements have been made between the procuring entity, which is the ministry, and the contractor, following reservation on the contract price, which culminated in 25% reduction. And the government still maintained that the price was expensive and unsustainable to bankroll. In light of the above, the ministry was terminating the contract with immediate effect in terms of clauses mentioned therein. Furthermore, it has been brought to the ministry's attention by the Reserve Bank Financial Intelligence Unit that you, Black Tech Private Limited, and addressed to Mr. Mpofu, the first accused, had sourced foreign currency on the black market using money which had been advanced for the program. And as you are aware, I continue reading the contents of the letter. it is against government policy to source foreign currency on the parallel market. The ministry cannot be seen to be associated with entities that source foreign currency on the parallel market. It concluded by saying, accordingly, you must deliver to the ministry holding centers GOTS that are equivalent to the total advance you were paid, failing which will recovery procedures will be instituted. The letter was signed by Professor Jiri, as accounting officer. He said that he was initially of the view that there would be no value for money because the goods had been priced at between 175 US dollars and 250 USD, which was, in his view, quite exorbitant. He said the ministry negotiated with the bidder, Black, and the prices came down to between 75 to 92 United States dollars, depending upon the breed. The price included the purchase of the goods, mobilization costs to the holding center, and onward distribution to faraway villages. This cost was factored into the price of each goat. The contract provided for advance payment, and when Blacktech brought a guarantee by Metbank, the ministry paid a total of 1.6 billion, which he said was equivalent to 7.7 million United States dollars. Thereafter, a number of meetings were held with Blacktech after it was realized that there was no progress in fulfilling the contract. Blacktech Private Limited subsequently wrote a letter to the ministry saying that the program was going on well and 32,500 goats were in holding pens pending distribution to targeted households. The ministry then embarked on a verification. The outcome of the verification is revealed in its report, which was produced by consent as an exhibit. The report was read in this court, and it described itself as the Presidential Goats Verification Report, prepared by the Ministry's Department for Livestock Production and Development, following an exercise, I'm reading from the document, to ascertain the number and classes of goats at various holding centers, following claims by Blacktech Private Limited that it had mobilized 32,500 goats, including kids. It further states that the exercise was aimed at confirming the availability of the goats at the holding centers and the locations provided by Blacktech Private Limited. It then goes on to list the various locations in Gurue, where 800 goats were said to be located, situated, at Murambinda Growth Point, at Mudindo Growth Point, at Mzarabani Growth Point, where the number of goats at Jimba, and the holding centers, where the holding center in Jimba was Kolenzo Farm, Chegutu District, where 2,500 goats were held at Sarue Farm, Makonde District, where 1,500 goats were held at Kolenzo Farm, Buyera District, where 2,000 Mashona goats were held at Beshnaf Bridge Holding Center, Chipinge District, Manikaland, where 2,000 goats were held at Bubi District in Mashona and West, where 5,000 Ndebele goats were held. The total number of goats to be confirmed by the verification was as stated before. The report went on to say that teams were dispatched to the various centers and they found only 850 bucks 2,548 doors, 325 kids, out of the 32,500 that they expected to find. The report said those were the ghosts that were physically located, which added up to 3,388. The report noted that the goats which were physically found in holding centers had a shortfall, created a shortfall of 28,612, which translated to 89.6%. The report also noted that the advancement had been made to black the private in the sum of in 2 batches, which added up to 7,712,197 United States dollars. And the average price of the goat was $90. So, if it was up to them, the goats would have been 85,000 goats, not even the 32,500 which Black Deck Private Limited. There were other recommendations there, which were that which appear there in the report. The witness said that in chasing up performance of the contract, the ministry dealt with the first and second accused persons. The first accused persons was the operations manager, and the second accused persons would attend all the meetings with him pertaining to the transaction. He said that the second accused person attended meetings, all the meetings that were convened by him. He said the second accused conducted himself in a manner that he assumed a leading role in the deliberations and made decisions. He said the ministry only got to know that the Zimra tax clearance certificate and NASA compliance certificate were forgeries from ZAC investigations. He said government of Zimbabwe suffered prejudice in that it paid in advance to Black Deck livestock and poultry and farming, but did not receive corresponding value in terms of the number of goats. Under cross-examination on behalf of the first accused person, he said the presidential scheme was important and should have been undertaken with seriousness. He said every bidder was required to submit 3 copies of the bid, 1 marked original, another, the 2 others would be copies, marked copies. The price of each goat included the costs of penning, keeping it in the pen, and security of goats and all other costs inherent. This witness was taken to task about remedies available to the ministry in contract law. We did not really consider that that line of questioning was relevant to criminal law. He said the negotiations resulted in a revised and reduced price, and Tinashe Chimombe, whom he said is a brother of the second accused, signed both the original and the addendum. We were satisfied that this witness gave his evidence well. He did not appear to have any motive to falsely incriminate the accused persons. He did not even make a criminal complaint against the accused persons to the police. The offense, as alleged by the state, was unearthed by ZAC. He did not appear to be shaken under cross-examination. We were satisfied that the crux of his evidence remained intact. he was a credible witness. After this witness's testimony, it became clear that the officials at the ministry knew that they were dealing with Black Deck Private Limited, despite the use of the other names. He said he was unaware of the requirement to register trade names. In his evidence, he did not stick to one name, but but all the names that he referred to had included Black Deck. He said at the ministry they did not appreciate the illegality of using an unregistered name. But otherwise, he said the use of the various names did not confuse anybody at the ministry. Nothing really, according to him, turned much on the names. They knew that they were dealing with Black Deck Private Limited. He we also find that the findings by the verification exercise regarding the number of goats that were found was not contested. In fact, it's not in issue. It's not in dispute, rather. And the evidence of this witness informs us that the deficit in performance regarding the amount that was paid to Black Deck Private Limited is 89.6%. The next witness is Bevan Mutsikamawe, who told the court that he is employed by the ministry under the company's deeds and intellectual properties as a principal examiner. He said Black Deck Private Limited was or is a registered company. He said a company could assume a name in terms of Section 29 of the Companies and Other Business Entities Act, and that the law came into effect in February 2020. A certificate is issued upon the registration of the assumed name, and the company is then allowed to use the assumed name. The company must file with the registrar a notice that it will be conducting its business under that assumed name, and would state that the entity's true name, and submit the constitutive documents of the company and the assumed name, and state in its papers that it intended to conduct business. And then the registrar keeps record of all that. Under cross-examination, the witness said Black Deck was registered in 2015, and that between 2015 and 2020 there was no law which compelled companies to register assumed names. The first accused counsel put it to the witness that Black Deck Private Limited was entitled to use the trade name, notwithstanding that it is not registered in terms of COB, because when the company was incorporated in 2015, the registration of trade names was not a requirement, and thus the COB did not operate backwards, did not affect previous conduct, which would be the assumption of that trade name. Isa Precious told the court that she is employed by the Ministry of Agriculture in the procurement unit. She handles bids by those responding to advertised tenders. She identified the third copy of the bid submitted by Black Duck Livestock Poultry Farming and kept at the ministry. It was produced as an official document in terms of Section 276 of the Criminal Procedure and Evidence Act. This witness, together with the witness from the registrar, gave their evidence well. In essence, the essence of their evidence was not really disturbed even after cross-examination. The witness confirmed that notwithstanding the different letterheads and the addresses used, the ministry, as far as she was concerned, knew that it would have been dealing with Black Duck Private Limited. Chennai Garissa Neta is a lawyer employed by the ministry as a deputy director. She presided over the evaluation committee as chairperson, which adjudicated on the tender, on the bids, over the bids. She said her committee did not do any due diligence in relation to the documents that were supplied. They obviously approached them in good faith. The members of the committee merely checked whether the documents were bearing the name of the bidding company. She said the ZIMRA tax clearance and the NASA compliance certificate appeared on the face at face value to be genuine. The committee did not verify the security features, despite that the documents on the face of them demanded to be verified by using the QR code. And verification numbers supplied. She then said the condemnation of the certificates by ZIMRA and NASA meant that the contract entered into between the ministry and Black Livestock and Poultry Farming was a nullity from the beginning. She said, as at the date of giving evidence in court, Black Duck Private Limited had not submitted valid ZIMRA tax clearance certificate and NASA clearance certificate to replace the counterfeits. She said the committee did not apply its mind to the various names or the provisions under Section 29, which required the registration of names. In cross-examination by both accused persons, it was put to her that the counterfeit documents belonged to the bidder, which is the company. This witness was truthful. The crux of the evidence was not really contested. She presented as a lawyer, a gatekeeper who failed in her professional duty. But that doesn't mean that she was not telling the truth. She was employed to do exactly what she omitted to do. She was employed to advise the ministry on legal matters. She was chairing the committee. She ought to have verified these documents. She still failed. But as I said, she was a truthful witness and did not attempt to deny her mistakes. She confirmed that she drafted the contract. We found her credible. Alban Mindurwa told the court that he's employed by the ministry at the relevant time. He was Director Livestock and Development. He said when the tender was advertised, the first accused person visited his office inquiring about the tender, and he directed him to the relevant department. Later, he heard that the goats were being bought, and he inquired from the first accused person, who confirmed that the tender had been awarded. On the 2nd of March, both accused persons visited his office, and he gave them advice on how the project was going to proceed and the guidelines. He said later, the accused person said they had mobilized 32,500 goats. He said the ministry decided to carry out the verification exercise, and we have already discussed the verification exercise above. He produced minutes of the meeting, which was attended by both accused persons. It's important to read that document. It identified itself as the Presidential GOT Scheme, GOT Verification Exercise. Pre-departure meeting with Black Deck Private Limited Company. Venue, Director Mr. Mindurwa's office. In attendance, Mr. Mindurwa, Director LPD, Mr. Chimombe, Director LPD, Mr. J. Taderera, Livestock Specialist, Minuting, Mr. Mpofu, Black Deck, Mr. M. Chimombe, Black Deck. Welcome remarks. Mr. Mindurwa introduced the LPD members present and highlighted that Mr. Chaderera was the official assigned to accompany Black Deck personnel for the verification of goats at the goat holding centers. There was instruction by the ministry. This was per instruction by the ministry Secretary for Lands, Mr. John Basera. The contract was to be led from the ministry to inspect and verify the number of goats at the holding sites, highlighted by the contractor, Black Deck Private Limited, in their correspondence to the department. Black Deck Livestock's position. In response, Mr. Mpofu, whom we know to be the first accused person, said that the initial verification report produced by the Department of Agriculture was incorrect, as they had more than this on the ground. He pointed out that the goats were not at central pen, but were scattered in communities. He said that there might be 50 to 100 farmers which might be holding stock, and they would take a lot of time to verify. And there would be cost implications. Mr. Mpofu also informed the meeting that he wanted to see the Secretary for Agriculture and Fisheries, and would soon after inform him of the complexity of the verification. DLPD's response, the director responded that the report was produced by other staff. Black Deck response, the company representatives agreed that it was an error on the part of the company on holding sites, as most of the goats they had purchased were in individual farmers' places. And the meeting ended at 11:45. So the witness presided over this meeting. He then eventually gave evidence of the outcome, which was then directed to the permanent secretary. In December 2022, the first accused person then announced that they would suspend the supply of goats. That was the witness testimony. Under cross-examination on behalf of the first accused person, it was put to him that the first accused person involved himself in the project as a representative of Blackstake livestock and poultry farming. He said and that it was put to him that the company failed to secure money on the formal market and it had to go to deal on the informal market for US dollars. It was also put to him that Blackstake transferred various accounts to try and secure foreign currency from the black market. The first accused person counsel for the first accused person put it the witness that the money was paid to the company and not to the first accused person. The second accused person, through counsel, put it to him that he was only implicated due to his attendance of a meeting at the ministry, and he was subjected to lengthy cross-examination and which insinuated that he was exaggerating his evidence. However, we noted that his evidence dovetailed with that of John Basera in as far as what he said was the participation and involvement of the first and second accused person. Both this witness and John Basera said they got the impression that the two of them were the faces of the company and the people behind the successful bidder through their conduct, their frequent attendances at meetings called, and their participation during deliberations and the decisions that they made during the deliberations. If believed, this witness would obviously suggest that both accused persons actively participated and associated themselves with the bid. Obet Jiri joined the ministry after the tender had been awarded. He was involved in the price negotiation with the winning bidder. He said the two accused persons were involved in price negotiations. He then spoke of the verification, which we do not need to repeat. He was cross-examined, and under cross-examination, he seemed non-committal in terms of the number of times that the accused persons, especially the second accused persons, attended the meetings. He gave his evidence well. He did not appear to be exaggerating. Where concessions had to be made, he made them. Then Sipiwe Mpadula's evidence was formally admitted in terms of section 314. In other words, she didn't have to come to court to give evidence. Her evidence, as summarized, was admitted in this court as the truth of what happened. She was being called to produce bank statements, which were eventually produced by consent. These were the bank statements of Blackstake Private Limited and Militech Enterprises. The statements reveal that the amounts that were disbursed by the ministry, and that the disbursements that were made quickly from the Blackstake Private Limited bank account, and the disbursements that were made from the Militech investments account. They confirmed the disbursement of 200 million USD to Militech Investments. The state then closed its case. The accused persons were put to their defense. The first accused person adopted his defense outline as his evidence under oath. He still maintained submitting the bid in his personal capacity. He still maintained that he was not involved in the procurement. He actually maintained his stance as stated in the defense outline. He said that there were two shareholders who were Jeneka Bisira and him. He said his main function at the company was implementation of products. He said Black Deck Private Limited traded as Black Deck Livestock Poultry and Farming. He confirmed that a decision was made to submit a bid. He described the face of the bid. He took the court through all the documents in the bid and explained them and their purpose, the purpose which they served. He, however, while he knew the purpose of the Zimra and NASA certificates, he could not comment on the alleged position that the Zimra and NASA certificates. Put differently, he could not say anything or much about the allegation that the Zimra and NASA certificates were fake, because as he said, that was within the purview of a different department at the company. He said he was appointed by the board to engage the ministry with respect to the terms and conditions of the tender which had been won, and he took part in those negotiations, which included the payment and delivery terms. The contract was eventually prepared and he signed it, and it was witnessed by Chimombe. Well, Chimombe. The name, correct name appears on the bid. He confirmed that 1.6 billion was paid in 2 tranches, and that he said there was no formula regarding how that money was to be used. It could have been used to put up infrastructure, to buy vaccines, and in fact, some of it was paid to the agents, which he named. The company received various figures. He maintained that the company could properly trade as Black Deck Livestock and Poultry, and despite the fact that the name was not registered. Under cross-examination, he admitted that he had 3 children with his co-director, Ajine Finas Kabisira. He said NASA and the company was fully NASA and Zimra compliant, and he knew that from the reports that he was receiving from the company. He did not understand. He said he could not explain how the company would have been deregistered by NASA when in fact it was compliant. But by and large, he refused to answer questions that related to compliance issues, because he said these were within the purview of another department, and he also refused to answer questions regarding, by and large, regarding the affairs of Black Deck Private Limited. His reason was that he was charged in his personal capacity and not in his representative capacity as director of Black Deck Private Limited. When he completed his own testimony, he then closed his case, and without calling the witnesses that he had listed. He said the NASA, the consultant had died, before he could evidence. He, however, did not produce any confirmation of the death. When pressed with regards to the Zimra certificate, which was alleged to be fake, he refused to answer more questions, saying that he had no authority to speak on behalf of the company. He said the amount the amount that was paid by the ministry was paid to the company, not to him. And he said the money was then traded on the black market. He considered that the amount sourced from the black market was not recorded and not accounted for, in the sense that it was not deposited into any bank account. He considered the provisions of Section 10 of the Bank Use Promotion Act, which required companies to bank in foreign currency in US dollars in excess, or rather, in foreign currency in excess of USD $200. He said it was the decision of the company not to bank the foreign currency that had been used. The second accused person testified that he is a politician, Central Committee member of ZANU-PF, is chairperson of its fundraising committee in Mashonaland West, is the founding president of the EEG, is a businessman. He said he's a director of Militech Enterprises Private Limited, which is a company registered in terms of the laws of Zimbabwe. He said he had ceased to be a member of Militech in 2021 when he started campaigning for elections. He said he had no relationship with Blacktech Private Limited whatsoever. He did not participate in the submission of the bid. Submission of the bid by Blacktech Private Limited prior to the signing of the contract. He said the only occasion that he had a meeting with Alban Mendua was when he was invited by the first accused person in his capacity as a member of the EEG. And he said he attended the meeting in that capacity with the intention to assist in resolving a misunderstanding. It turned out that there was no misunderstanding. So in the meeting, he did not say anything because there was no issue. He said subsequently, Militech was engaged as an agent by Blacktech and was paid some money for the procurement of goods, and Militech performed its obligations. It is still owed some money by Blacktech Private Limited. He did not know why he was being arrested in connection with this case, which is a case to do with Blacktech. Under cross-examination, he said the first accused person is his close friend, and when asked whether they documented their business transaction, he said they did not. They just do business. He said he left Militech. He said the fact that he left Militech in 2021 meant that in by September 2021, he was already resigned from Militech. But he wasn't sure whether he had been removed from the list of directors. He said when he was asked whether he was involved in the tender processes by the bid submitted by Militech, he said he did so, as his involvement was that he was consulted during the relevant period. When paragraph 11 of his defense outline was brought to his attention, he then said he was still the director of Militech at the relevant period, which is the time that the tender was flighted. He then said that Militech has got a written agreement with Black Tech over the issue of the goods, but he was not going to produce it because he was appearing in his personal capacity and he had no obligation to produce company documents. He agreed that Militech received 200 million Zimbabwe dollars. When pressed, he refused to answer more questions regarding that money because he said he was being charged in his personal capacity, not as a director of Militech. He considered that the foreign currency was not deposited in the banking system. Both accused persons closed their cases. Both accused persons made written submissions which are on record. Suffice it to say that the state moved us in general to find initially that the accused persons were behind this bid and had submitted this bid and had done so under the guise of Black Tech livestock and poultry farming, an entity which purported to be registered in terms of the laws of Zimbabwe as a company, but yet it was not. They said the use of that name was deliberate so that in the event of anything arising, they would escape liability. The state moved us to believe the witnesses. I have already indicated that we believed the state witnesses. The state gave us a lot of authorities regarding sufficiency of evidence in criminal cases, the law on inferences, that is circumstantial evidence. I do not need to repeat that because there's no real contest between the accused persons and the state on the law that is applicable to sufficiency of evidence, the law that applies to circumstantial evidence. There's convergence. The cases will obviously appear in the judgment as they are listed here, but I don't need to discuss them because there's no dispute regarding that area of the law. The state then submitted that Section 277 of the Criminal Law Codification applied because the first accused person and Kabisira actively participated in the whole process, the series of events, the various acts that constitute the fraud alleged by the state. The state urged us to find that Kabisira had participated minimally in that she had submitted the bid, but the first accused person had participated actively in that he negotiated the prices. In other words, he was there from the inception of the project. He was part of the decision-making board that decided to submit the bid. He was aware of its requirements. He was aware of the requirement of valid tax clearance. He was aware of the requirement of a valid compliance certificate. He ought to have been aware of any disabilities that inflicted the company in terms of its ineligibility for tax clearance, ineligibility for NASA compliance. The state urged us to find that, therefore, he was personally responsible and liable for the misrepresentation that was made through the bid, because he had no reason to expect that there would be a valid compliance certificate and tax certificate when, in fact, he ought to have been aware of the financial position of the company. The state urged us to reject his submission that he had no knowledge of the counterfeit documents submitted with the bid, for the reasons that they gave, which I've already alluded to. He said the state also urged us to find that he was part to the misrepresentation that the performance of the contract was in course, and that 32,500 goats had been secured, and that he was also party to the decision to trade the foreign currency that was received from the ministry contrary to the law. And the state therefore submitted that he was therefore personally liable to be prosecuted for the crime of fraud. The state submitted that the fraud consisted of a series of acts which started with the preparation of the bid, the collection of the documents, the compilation itself of the bid, the misrepresentation made during the operationalizing of the bid that had been awarded to Black Tech Private Limited, and the conduct which resulted in the ministry disbursing the funds. The state urged us to find that that series of events constituted the various acts which constitute the criminal conduct, which was all aimed at causing the ministry to act on the various acts of misrepresentations in order to pay the money, which was then eventually misappropriated and traded on the black market. The state urged us to find that the fact that the money has not been properly accounted for means that the money was misappropriated. The state urged us to find that the first accused person cannot hide behind any veil of protection against the crime because he participated in all the acts that constituted the offense. The state submitted that in any event, the corporate veil is not available to directors of a company in criminal law. With regards to the second accused person, the state urged us to find that his active participation in the discussions and operationalization of as soon as the bid was meant that he was in fact also behind the bid. And as I've said, the Act draws referred to Section 277 and said it also applied to the second accused person, in that he may have not been on the CR14, but he was directing and controlling the affairs of the company. The first accused person in his closing submissions moved us, prayed for acquittal on the basis that it was not correct that Black Tech livestock and poultry farming does not exist as a company. He said it exists. It is the name, it is the other name of Black Tech Private Limited, and therefore a trading name. And together with Colenso, he submitted that he could not be held personally liable for conduct of a body duly constituted without lifting the corporate veil. He therefore said that no criminal conduct had been established against him in person. He said it is the company which participated in the contract using its two trade names, Black Tech Livestock Poultry Farming and Colenso Farm. He submitted, or rather it was submitted on his behalf, that while as from 2020, companies were required to register names which they were going to use as trade names. They were only a company could only use one name, trade name, and sorry. They say that he said, I think I read that again, expunge what I've said, that although the Act as from 2020 required companies to register trade names, the Act would not apply to the trade names because the provisions did not apply in retrospect. In other words, the Act coming into existence or being promulgated in 2020 would not apply to trade names already assumed prior to its promulgation. The argument therefore was the names had already been assumed and the company was entitled to continue using them, notwithstanding the provisions of the code. He submitted that he did not misrepresent at the drafting of the contract because it was drafted by the ministry. The first accused person referred us to case law as authority for his proposition that before being criminal liable, the state was required to pierce the correct veil. He cited Musendo and Kasuso versus the state, HH 289 of 17. This is a civil matter where it was held that the first requirement sorry, there must be an error here. That is to pierce the corporate veil. He also cited case law relating to assessment of evidence, circumstantial evidence, indirect evidence, and sufficient evidence, and the incidents of honors, which we have already alluded to. As I said, there's no need for us to really go through the law because, as I have already stated in the beginning, the incidence of honors is stated in section 18 of the codified criminal law. And there's issues of sufficiency of evidence and the application of circumstantial evidence in determining a verdict, whether or not an accused person is guilty, is not really the subject of any dispute amongst the but I must quote S versus Katsiru, which they said is authority for the fact that a conviction cannot possibly be sustained unless the judicial officer entertains a belief in the truth of the criminal complaint. And failure of the accused to win the faith of the bench does not disqualify him from acquittal. Proof beyond reasonable doubt demands more than a complaint to be believed or that the accused be disbelieved. It demands that the defense succeeds whenever it appears reasonably possibly true. He submitted that the accused person could only be charged in his personal capacity if the company was also charged with him. In other words, the state, in order to succeed, had to say he committed the alleged acts or omissions in his capacity as director, and he was responsible, personally responsible for those actions. Without that, then he would not be liable to be convicted in his personal capacity. I now come to the case which I was looking for. They cited Deputy Sheriff versus Twin Park Investments, HH12 Harare High Court, 121 of 11, where Patel J, as it then was, quoted with approval a South African case of Cape Pacific Limited versus Lubna Controlling Investments Private Limited and others, 1993 case. It says, it is undoubtedly a salutary principle that our courts should not lightly disregard a company's separate personality, but should strive to give effect to and uphold it. To do otherwise would negate and undermine the policy and principles that underpin the concept of separate corporate personality and the legal consequences that attach to it. However, they seemed to concede that that separate personality would not absolve the accused person, because in the same case, the court says but where fraud, dishonesty, and other improper conduct is found to be present, other considerations will come into play. The need to preserve the separate identity would, in such circumstances, have to be balanced against policy considerations which rise in favor of piercing the corporate veil. And a court would then be entitled to look into the substance rather than the form in order to arrive at the true facts, and if there was any simple misuse of corporate separate personality. I must observe that this case cited was decided in 2011. That was the application of common law. Our law is now codified. It was codified subsequent to that judgment. And clearly the first port of call when one considers criminal liability of directors of a company would be the code itself. Yeah, the code says case law can be helpful in interpreting the code, but the first port of call should be the code. This is because in the preamble to the code, it says the purpose was to modify and collect all principles and modify them and perhaps reject other principles of common law. So while the statements are correct, we preferred first to rely heavily on the codified law, which is the current law, to the extent that it may be inconsistent with the common law as previously stated in our judgments. The first accused person through counsel considered that a company director who commits a crime while going about his company's business is attracts personal criminal liability under Section 318 of the Companies Act, as read with Section 3857 of the Criminal Procedure and Evidence Act. Because they cited the case of S versus Love More Kurotwi. Let me just say the case of S versus Kurotwi and Mbayowa, HH 270 of 2016. But they, however, maintained that it was necessary for the state to adduce evidence that when in the particular circumstance of this case, that the accused person did certain things, these things, in pursuance of company business. We observe that that submission insistence on the fact that the state ought to have proved that the first accused person, did all acts in his company, in his capacity as director of Black Tech Private Limited, is baffling. That was not really disputed. The state alleged in the state outline that the first accused person is a director of Black Tech Private Limited. In fact, it was the first accused's position in the defense outline that the bidder is Black Tech Private Limited, and that he only participated in his representative capacity, and that all acts or omissions that he did or that are attributed to him, which at least those that he admits, he did them on behalf of Black Tech Private Limited and in his capacity as the director. In terms of our law, there's no need to prove something that is admitted. That was admitted. So clearly, by his own cases, if indeed there was criminal conduct arising from his, anything criminal arising from his conduct, such acts and omissions were done while he was advancing the interest of Black Tech Private Limited, which he says was the company that he represented. So that submission, for some reason, although it was meant, was shot. Rather, the first accused person shot himself in the foot, because he then provided the cases, and then he said that he said all he did was in the capacity. In his capacity as director of Black Tech, and that he was duly authorized to do that. He said there was a resolution authorizing him to do that, which he produced in this court. So there was no need for further proof by the state. In fact, that was his defense outline anyway. The second accused person submitted closing submissions, which were quite concise. He said the sole question at the close of the trial was the following: has the test proved its case of fraud beyond reasonable doubt? He said this case is strange in that, with respect to the second accused, the trial closed without the state focusing on how he had been said, how it can be said that the second accused made any alleged misrepresentations. And he said the test for proof beyond reasonable doubt is settled He said if emphasis must be placed on that, if an explanation given by the accused person, or if the accused given by the second accused person cannot be said to be false beyond reasonable doubt, then there is no proof beyond reasonable doubt. He said the second accused person's defense was fully supported by his unshaken evidence. He cited S versus Kuipa, which I must read. Said the test to be applied before the court rejects the explanation given by the accused was set out in a South African case which is studied therein, and that is the Deaford case, celebrated Deaford case of 1937. No onus rests on the accused person to convince the court of the truth of his explanation. If he gives an explanation, even if that explanation is improbable, the court is not entitled to convict unless it is satisfied. Not only that the explanation is improbable, but beyond reasonable doubt, it is false. If there is any reasonable possibility of his explanation being true, then he is entitled to his acquittal. They also cited the Makanyanga case, which says that the failure by the accused to win the faith of the bench does not disqualify him from acquittal. And then the other cases there, which have been cited by all the parties here, and regarding sufficiency of evidence, or what constitutes proof beyond reasonable doubt. Importantly, which does not relate to, and they said the application of the law to this case is that from the above law, the state's attempt to rely on circumstantial evidence cannot even begin, because there's no proved facts that qualify as facts under the two cardinal rules in R versus Bloom. By the close of the trial, those were the submissions, the state had not brought the second accused person into the trial. Counsel criticized the state for attempting to link the accused person through the following four circumstances, which are listed as that he approached Alban Mindurwa while in the company of the first accused person for advice and how to proceed. That, I should have said, that he allegedly approached him, that he allegedly participated in meetings, that he, on the 7th of February 2023, he attended, that of course is common cause, a meeting at the Ministry of Lands to find a way forward in respect of the progress of the Canada, and that he he attended the launches for the God scheme. Those are the four circumstances which, according to the second accused person, the state sought to rely on. Counsel said even without going into the truthfulness and otherwise of the alleged defense. Firstly, the four circumstances relate to alleged events after the award of the tender. That was after the commission of the offense. The offense of fraud is committed at the point that the misrepresentation is made and the subsequent inducement of the victim to act to his prejudice. The offense would have been committed at the time that the tender was awarded, and all these other circumstances arose after. So, those circumstances, even if proven, did not link the accused person, the second accused person, to the crime. Secondly, and in any event, the second accused person gave a completely convincing response to each of the alleged circumstances as follows. He never went with Alban Mindurwa in the company of the went to see Alban Mindurwa in the I must take that again. He never met Alban Mindurwa in the company of the first accused. He said he challenged Mindurwa's evidence in cross-examination, and he further solidified that position through his own evidence. In chief, he said his version was not seriously challenged under cross-examination. He said Mindurwa did not produce any meetings, any minutes of the various meetings that he alleged he held with the second accused. He said it was not true that he participated in negotiations in respect of Blackdeck's performance. He said the evidence of Obed Jiri was speculative. In fact, Obed Jiri did not persist and with his evidence, what he had said regarding the second accused person when he was under cross-examination. I will repeat that. In fact, Obed Jiri did not persist with what he has said against the accused person in his evidence chief when questions were put to him under cross-examination. He admitted attending only one meeting where he appeared in his capacity as the member of EEG and as a personal friend of the first accused. He wasn't representing Blackdeck. He attended the lounges as a politician. He said the circumstances were therefore either not true or adequately explained. He said the state attempted to link him through what it called association. There was absolutely no basis for the doctrine of association, as no legal authority is cited for its invocation. He said his company, Militech, submitted a bid. It was a competitor of Blackdeck Private Limited. It would be wild to suggest that the second accused person would then participate in the tender process by Blackdeck. The second accused was subcontracted by he said his company, Militech, was later subcontracted by the winning bidder. So there was no evidence to link him with the alleged misrepresentation, that is the documentary exhibits which were alleged to be false. In conclusion, counsel submitted that on behalf of the second accused person that the second accused person's defense was clear and unambiguous. He just did not make any misrepresentation or the alleged misrepresentation. He never submitted any documents, so there was no link between him and the tender documents. he prayed for his acquittal. We were required then to, on the basis of the evidence and the submissions made to us, to consider whether the state had established his case beyond reasonable doubt. We have already alluded to what the state had to prove and the issues that arose from the pleadings, the state outline and the defense. We have already identified that. We will therefore deal with the identity of the bidder and its registration status in terms of the laws of Zimbabwe that govern registration of companies. The bid document was produced as Exhibit 14. Conspicuous on the face of the bid was the name Black Deck Livestock and Poultry Farm, which was in capital letters and written in bold, as I have said, and with mixed black and red. At the top left corner is a small logo written Black Deck Private Limited. The address which appears on the face of the bid is 8 Carson Close, Grindle. The first document in the bid is a letter signed by T.H. Dembo addressed to the procurement board. There's also, there are letterheads in the bids for Black Deck Private Limited trading as Colenso firm with an address at the farm. There are documents, there's a letter on the letterhead of Black Deck Livestock and Poultry Farm with a small logo of Black Deck Private Limited. There's also a Sierra 14 of Black Deck Private Limited, and they required the Sierra 14, which identified the directors as Mpofu and Ajine Kabisira. In considering the issue of the identification or identity of the bidder, we took into account the first accused person's submission that, in fact, for all intents and purposes, the bidder was Black Deck Private Limited. Nothing turns on the other names because they were just trade names, and that there was really nothing much to be achieved by the use of these names. We took into account the evidence of the witnesses who said that they were not misled by the use of these names. They knew that they were dealing with Black Deck Private, which they considered to be a registered company. And it appears to us that before I say that, the first accused person said that the decision to use Black Deck livestock and poultry farming was deliberate on the part of Black Deck Private Limited and on his part, because he was part of the decision to submit a bid, and the decision to use Colenso Farm was also deliberate. It appears to us that this may have been motivated by the fact that those names were more relevant to the purpose of the tender. This tender involved livestock and livestock. A name which has livestock as part of it would be more appealing, and the reference to a farm would obviously validate the company profile which was submitted with the bid. There's a company profile which was submitted with the bid, which is various, which shows the structure at the farm, the activities at the farm, and livestock are depicted in pictures and introduces veterinary experts and so on. So naturally, this would be more persuasive. We also accepted the submission by the state that blackjack livestock and poultry was not registered as a name, was not registered as the name or trade name of an entity. The name would have been not registered, but we go back to the issue that we raised. Was the use of that name made with intent to deceive or to cause the ministry to act to its prejudice? The name was invalid, was not supposed to be used, but it was used all the same. Could it be said that the intention was to bring about prejudice? In view of what appeared to be common cause and what the witness said, we believe that the names were used, as I said, to add some color to the, but not really that the ministry would be deceived as to the entity it was dealing with. The ministry was not deceived. It was dealing with Blackjack Private Limited. The award was made, although names were used interchangeably, different names were used interchangeably, but the letter from Praz is clear that it was being awarded to Blackjack Private Limited, and in fact the money was dispersed to private. So clearly, in terms of who it was dealing with, the ministry was not deceived. We are therefore not satisfied that although the state proved that blackjack livestock and poultry farming was not registered as the name of any company, we could not infer that the use of that name was meant to disguise or distort or confuse. I mean to deceive the ministry as to the registered entity that it was dealing with, because then documents that were submitted were the certificate of incorporation of Blackjack Private Limited, the CRA 16 of Blackjack Private Limited, the CRA 14 of Blackjack Private Limited, and as I've already said, the ministry dealt. The state of mind of the ministry, as deciphered from the witnesses, was that they were dealing with Blackjack Private Limited. So, what the state proved, as I've said, that the name was not registered, would not have sufficed as would not have sufficiently constituted fraud. But the matter does not end there. The state alleged other forms of misrepresentation, which are that the Zimra tax clearance submitted to the bid was counterfeit, and that the NASA compliance certificate submitted with the bid was counterfeit, and that the performance of the contract was going on well, which was intended to induce the ministry to part with funds. In other words, the state says a false statement was made that 32,500 goats had been gathered, when in fact that statement was false. It was one of the series of acts which were committed for the purpose of inducing the ministry to part with funds. It had that potential prejudice. Clearly, at the end of the trial, as submitted, as testified to by one of the state witnesses, is Garise, Blackjack Private Limited, or the accused persons, had not placed before this court evidence that, contrary to what we saw on the tax compliance certificate, which would mean that the companies were not tax compliant because they would have relied on fake documents. The company was in fact tax compliant. As regards the NASA compliance certificate, proof was there in the fact that the Black Private Limited had been deregistered, and there was no evidence, apart from the mere say so by the first accused person that he saw certain reports that payments were being made. We believe that the failure by the first accused person to call the witnesses that he intended to call affected his credibility, affected his defense. These were witnesses that he considered necessary, even as he knew at the beginning of the state case that he was being charged in his personal capacity. He knew that these witnesses were important, material to his defense, as he was being charged in his personal capacity. They were indeed, because he had to extricate himself from the criminal conduct for which the company could be charged. His decision not to call these witnesses was his own, for reasons best known to himself, except the explanation that we received that one of the witnesses had died, which explanation was not verified in the usual way by the production of proof of the existence of that witness and the death of that witness. Ordinarily, which should be the case in this case, where a litigant threatens to call witnesses to confirm his or her defense and later abdicates or fails to call that witness, the usual inference is that probably there was no serious intention in the first place to call that witness, or that the litigant realizes that if the witness is called, he will not confirm the position taken by the litigant. In other words, where one is undertaken or of their own volition to call a witness to confirm their case and they abdicate from doing so, adverse inferences can be drawn from such conduct. And in any event, that affects the assessment of the credibility of their evidence. The explanation given by the first accused, is that he did not have to call these witnesses because he realized that he was being charged in his personal capacity. That explanation is not convincing at all. This is because, as I have said, when he gave his defense outline, he knew that he was being charged in his personal capacity. But he considered that the witnesses were important. So at what stage did he change his mind? Did he consider that those witnesses would not be relevant to his evidence? He insisted that he was not being charged in his capacity as a representative of Black Private Limited. That was the submission by Mr. Koto, who said the charge is specifically alleged that he is personally liable because he is a director of, he did the acts in his capacity as the director of a company which would have been liable to be charged. We do not agree with that submission. We also do not agree with his understanding of criminal liability as created in Section 277 of the Criminal Law Codification and Reform Act. We have already referred to the South African case, where the South African court expressed reservations about the applicability of the corporate veil in cases involving fraud. and other cases of dishonesty. We have already said that that was the common law which expressed those reservations. We have already said that subsequent to that, our law was codified. Clearly, the codification of 277 was to deal with that mischief, was to conflict the director and the company, in the sense that because the director, a company is not is just a person in the eyes of the law. The term that is usually used is that it is juristic person or a fictional person which is then given certain capacities at law as if it were a natural person. It's really not a person created by God as we know the natural person. It is a person created for the purposes of conducting business. And then it is given certain capacities which are attributed by law of persons to capacities to do certain things with legal validity. But it being a fiction, you can't touch it. It does not have a brain of its own. It does not have a mind of its own. It does not have a soul of its own. It does not have limbs of its own. It conducts its business through the agents of natural persons. So it's very difficult to separate the acts of a company from the acts from the board which makes decisions on behalf of the company. And that's the whole, in our belief, that is the whole essence of Section 277. Section 277 deals with criminal liability of corporations and associations and their members, employees, and agents. Subsection 1 defines director. Director in relation to corporate body means a person who controls or governs that corporate body, whether lawfully or otherwise. Or is a member of a board or a group of persons which controls or governs that corporate body, whether lawful or otherwise. This company was controlled by a board. The first accused person was a member of that board. So he was a director of this company. Subsection 3 says, where there has been any conduct which constitutes a crime for which a corporate body is or was liable to prosecution, that conduct shall be deemed to have been the conduct of every person who at the time was a director or employee of the corporate body. I just pause there to record what we meant when we said we differed with Mr. Koto's interpretation. He said the corporate body must be charged with the accused person for personal liability to attach. I don't know where he's getting that. We would accuse him of rewriting the law because subsection 3 is unambiguous. It says, for which a corporate body is or was liable to prosecution. That is not the same thing as saying for which a corporate body is being prosecuted. A corporate body would have been liable, but the state may decide not to charge the corporate body. That does not defeat the prosecution of its director, who provided his limb, who provided his soul, who provided his mind in the actions giving rise to the criminal conduct for which a company could be charged. The court recognizes the independence of the prosecutor general to institute prosecution. We are aware from the published prosecutorial guidelines that the prosecutor general considers the sufficiency of evidence test and the public policy test. That is a public document which was published by the Prosecutor General in terms of the Constitution. So the court takes judicial notice of that. So the state may decide not to prosecute, but that does not absolve a director, as I've said, who provided his amenities to if it is shown that he provided his amenities in the offense. And such a director is liable personally if his conduct was accompanied by the intention on the part of the person responsible. This person responsible with the company. This is the natural definition of a crime. If you look at the beginning of the Criminal Law Codification Act, any person is not liable unless certain acts and omissions which constitute criminal conduct are proved against that person, and unless it is shown that the requisite state of mind, criminal state of mind. So there's nothing really spectacular about this, except that it really says any director who does, where a company is liable to be charged or was liable to be charged, its director can be charged or is also liable. The fact that one is a director gives rise to that liability, which can only be escaped by resorting to the proviso to that section, subsection 3 of section 277. It says, provided that if it is proved that a director or employee of the corporate body took no part in the conduct, this subsection shall not apply to him. That is very critical. The first accused person must have been aware of his obligation to extricate himself from this situation, where he is a director of a company that submitted a bid which contained a falsified tax clearance, which contained a falsified NASA compliance certificate. That act then becomes his, unless it is shown, it is proved that the director, which means him, took no part in the conduct. That must have informed his decision to call witnesses who were going to show that he was absent when all these things were happening. He then decided not to call those witnesses. The question is onus. Who has the onus to show that he took no part? Is it the accused person who is charged or the state? Section 18 is helpful. In any event, invariably, where a presumption gives rise to criminal liability, and the person charged, which means would be the first accused person, relies on a proviso as his defense that he did not. At the very least, he has the onus on the agreed with the agreed standard to show that he did not take part. The state does enough when it proves the criminal conduct of a company for which he is a director. Then such conduct is presumed to be his. Now, when he wants to escape liability or conviction, he must then demonstrate, which is simply what onus means. Onus is that duty to place before the court facts, the facts which demonstrate or prove, which are enough for that defense or that position to succeed. Subsection 5 says a person who is criminally liable in terms of subsection 3, which I have just been reading, shall be liable to be prosecuted and punished personally for the crime concerned. So, there are a submission that he should not be prosecuted personally in circumstances where criminal liability arises. Clearly, it's not correct. The first accused person was also aware of the provisions of the law, which, as I said, cited the Companies Act, the Companies and Other Business Entities Act, which say a director who has been involved in dishonest behavior cannot be absolved, cannot be behind the corporate veil. They also referred to subsection 385 of the Criminal Law Codification, the Criminal Procedure and Evidence Act, Chapter 907, subsection 7. Which we says it is possible for the accused in criminal procedure to be charged in his personal capacity. When the company and the accused and its director are charged together with the conviction of crime, they are co-accused persons. They are each liable for conviction if the state proves their participation separately. In other words, but that doesn't. In other words, the company could still be guilty, and the director can escape liability if he fulfills the requirements of the proviso to subsection 3. An accused person is only charged. It is not correct that an accused person is charged in a representative capacity. No, that may be confusing, and that may be what confused Mr. Koto. It is the company which is charged, and in terms of procedure, section 385(3). We have already said the company can be touched. It has incorporeal personality. It can be touched, so it can be in the dog. So in terms of section 385 or subsection 3 of the Criminal Procedure and Evidence Act, in any proceedings against a corporate body, a director or employee of that corporate shall be cited as representative of that corporate body as the offender, and thereupon the person so cited may, as such representative, be dealt with as if he were the accused of committing the offense in question. This is just a procedural aspect. It is up to the state to decide, but more likely than not, they drag the director. But the company can still put forward another representative, which means an employee would still be acceptable. But that does not mean that that person is named as the accused person. The person who is named as the accused person is the company. And the accused person appears because it is only the person who can speak and answer questions. So I suppose Mr. Koto was confusing substantive law creating criminal liability and procedural law which governs how a company which is liable is prosecuted. He also referred to subsection 7, which is correct, which says that in any criminal proceedings against a director, any evidence which would be and shall be admissible against the corporate body in the prosecution for that one shall be admissible against the accused. So, where the accused person was charged in his personal capacity, because you can't really separate his conduct from that of the company unless he does so successfully, then evidence which would have been used to prove the criminal conduct on the part of the company would be used, would also be admissible against him, and would prove criminal conduct on his part. That is what subsection 7 of section 385 is saying. So all the evidence which was led would also apply against him. And that is then there's also subparagraph A, which says whether or not the corporate body is or was liable for prosecution, any document which was under the control of the company or any such director shall be prima facie evidence of its contents and admissible against the accused. So this bid document would be admissible against him as evidence against him, and a prima facie proof against him of its contents. To the extent, as you said, it is relevant to the offence charged. Even if that person was not was not a party to the drawing of the document, the memorandum and record. Clearly the legislature is just trying to deal with cases of mischief where people will say, oh, I did this wearing my hat as a company representative, which means that what my conduct, even if it is wrong or criminal, it remains with that entity which I was representing when I was wearing that hat, and such personal liability cannot attach to me. You can see the legislature systematically dealing with that eventuality, that defense, completely removing that defense, literally dismantling it when it comes to directors of entities. The second accused person, this company, Black Deck Private Limited, on the face of it, in terms of the bid, had 2 directors. The state was clearly unaware that there was another director. Tinashe Chimombe, who signed the contract. We only became aware of that. That Tinashe Chimombe, sorry, just bear with me. Excuse me. Registrar. Can I have that red file? Can I have that red file? That red file. Yes, I was confusing the first name. It is actually Tinashe Chimombe. We only became aware during the proceedings when the first accused person said Tinashe Chimombe is actually a director of Black Deck Private Limited. In other words, relying on the Sierra 14 alone, that fact would have been unknown up to this stage. The significance of that is that there was at least one other director who does not appear on Sierra 14, who was a de facto director of this company. And the law does accept that. The law is aware of that. It says in the definition section, which I read, section 177, subsection 1, a person is a director if he controls the activities of that company, whether lawfully or unlawfully. So for the purpose of criminal law, yes, Tinashe Chimombe was a director of this company. Which means that 3 persons, at the very least, 3 persons would have come together. Moses, Mpofu, the first accused, Kabisira, and Tinashe would have decided that they were going to submit a bid, and they used Black Tech Private Limited as their vehicle to submit a bid. So as at that stage, they had agreed that they would all be controlling that company, notwithstanding the lawful position regarding the directors as, appearing on phone. The second accused person, I've gone through his evidence, I've gone through the cross-examination, strenuously denied that he had much involvement with this contract, with this bid, with this scheme. That, of course, is the reason why they said that it is nowhere near there, because he was not involved. The corollary of that is that if he was active in participation and associated himself with this bid, then an inference can be drawn safely that he was controlling the body that submitted the contract. We were faced with a situation where we had his version, rather put correctly, following the incidents of honors, where we have the state case against his denial. We must resolve that factual dispute. Did he participate to the extent that is alleged by the state? That dispute can only be resolved by reference to the testimonies of the various witnesses who were called by the state. Was that testimony believable? Did we believe it? Did we find the witnesses credible? Should we believe them? Then there would be a prima facie, case against him if we believe them. But that should not necessarily mean that it will result in conviction. We will have then to deal with the explanation that he gives for such conduct. And if his explanation is reasonably possibly true, the law goes as far as saying even if it is improbable, but if it's reasonably possibly true, if it cannot be said beyond reasonable doubt it's false, then you should still be acquitted. With regards the second accused person, we resolved the dispute, the factual dispute concerning what the state alleged to have been his participation, and what the witness said was his participation in favor of the state. The witnesses, I've already said, John Basera and Mindurwa say that each time they asked it or they called for Black Tech, the two accused persons would appear. And that they were involved in that they made authoritative decisions. We believe that. We therefore find that the second accused person participated to the extent that was testified to by the state witnesses. His explanation was that although he may have participated at least one, but we have already found against him in that regard, because he said he attended at least that meeting that he admits in his capacity as director of EEG, which is a body, an empowerment group, which lobbies for positive discrimination in favor of local entities, indigenous companies, in awarding business, government business, government contracts. That explanation, we did not find it convincing, because if he said he attended the meeting which was chaired by Mindurwa, the pre-verification meeting, then that would have had nothing to do with lobbying for the award of contracts to Black Duck Private Limited, because at that stage the contract had already been awarded. So EEG would have been irrelevant at this stage. He obviously had another reason to attend. He then says he attended because he was wearing that hat and he had been invited by the accused, and he was going to assist in resolving disputes that had arisen. Is that explanation reasonably possibly true? We do not accept that, because in his own words, he said there was no dispute action. So what is it that he said he had been invited to attend to? He says there was nothing really which would require his involvement as a member of EEG. So then how did he involve himself? Then he said he attended because he had been invited by the first accused person, who is his close friend. This was company business. The second accused person says his company had submitted a bid. He knew that any affairs, anything to do with this, would be concerned with Black Duck Private Limited, which is the company that he knew. Black Duck Private Limited is not his friend, so why would he be there to attend to business? Right. We also find that his explanation, innocent explanation, is not reasonably possibly true, because it was contradicted by the first accused person. The first accused person said Black Duck Private Limited decided to appoint him to represent its interests in its dealings with the ministry, which means that he would have been co-opted and he had been given powers to interact with the ministry on behalf of Black Duck Private Limited. So how does that explanation by the first accused person, how does that evidence by the first accused person reconcile with his position that he only attended there as an observer at the very best, or perhaps in anticipation of his role as a member of EEG? The first accused person, he had a mandate. The question is, we know that in giving evidence, he then said he never received a mandate. We are not sure that the first accused person was subjected to rigorous cross-examination on this very telling point of his evidence. But anyway, the second accused person in giving evidence then said he had no mandate, creating another dispute between the accused persons themselves. But it is our law that when it comes to the stage of giving evidence which should be given in court under oath is admissible against a co-accused person. We found that the version of this first accused person regarding that he had been co-opted to represent the interests of, or appointed, whichever word we want to use, to represent the interests of Black Dialects Limited was more in accordance with the testimony of the state witnesses. We also said, why would the first accused person falsely incriminate the second accused person, whom he had tried to exonerate throughout the evidence. So to that extent, we believe that we considered that the second accused person was in a similar situation where he was, in all the circumstances of this case, controlling the affairs of this company, because he was mandated to go and represent it, make decisions on his behalf. So he then becomes covered by the definition of a de facto director in terms of Section 277. And his liability flows from his participation. The state cited the case of S versus Tinashe U. Sibanda to prove that participation at any stage in the series of acts which constituted the offense is complicit in the crime. Mr. Maduku submitted that that case would only apply if it is shown that the second accused person had the requisite knowledge. In other words, well, even if the court finds that he participated at some stage, or at those stages, as we have already found, as testified to participate, then but there's no evidence that he was aware that the bid contained falsified documents. But we accept that strictly that would be the application, but in a situation where the law contemplates de facto directors, and where we have evidence that this company was put forward as a trading vehicle by people, even by, at the very least, somebody who was not a party of that, we find that he was in fact in control of this company, and he would be liable and he would be deemed to have known. Because if he did put forward this company, he ought to have known its financial position, its compliance with the requirements. Those ought to have exercised this mind. Must have exercised this mind, rather, not ought. Must have exercised, he must have known or realized that it did not have these documents. There was a forceful submission that the second accused person bidded for this contract through Militech investment, and it would be absurd to say that he would have participated in the preparation of the bid of a competitor. Yes, but there's nothing really preventing a person from casting his or her net wide. Absolutely nothing, because one would also ask, was it a coincidence that he wanted to participate and lost and ended up participating by being appointed, rather his company, which would be him, participating as an agent? What does that show? We find that was not. We also examined how the accused persons dealt with this man, with the money. But before doing that, I needed to deal with the elements of fraud, which are the effect of misrepresentation. That is obvious. That is not denied. That the submission of fake documents actually deceived the ministry to treat the bid as valid when in fact it was supposed to be disqualified. Because if we look at glance at the minutes of the valuation board, they stated that certain companies were disqualified for not meeting the statutory requirement, the mandatory requirements. So clearly, if the falsification of the two documents had been known, Black Declaration would have been disqualified. So the the ministry was misled and treated this the bidders. Prejudice. There's obvious prejudice in awarding a bid to an eligible bidder. There are many cases where unqualified people fraudulently got teaching positions using fake certificates and taught well, but they were still found guilty of fraud, because fraud is committed at the time of making a misrepresentation. The fact that you later on deliver is neither here nor there. Then the other competitors lost. One would say perhaps this is not the prejudice alleged by the state, but the law is clear that fraud is committed even if the person who was prejudiced is not identified. Then there was obvious prejudice in that clearly the bidder then misbehaved. The whole presidential scheme is now a flop. And verification exercise revealed a monumental loss. We would refer to that the deficiency was 89%. So we find that the accused persons were correctly charged in the personal capacity, and that the evidence adduced established the state case beyond reasonable doubt against both of them. We therefore find them both guilty as charged. Yes.
My Lord, if you could just bear with the bar.
My Lord and Honorable Assessors, the state, in addition to the provisions of section of SI 146 of 23, the state wishes also to proceed in terms of section 50 of Money Laundering and the Proceeds of Crime Act, chapter 24.31.
Oh, you said in terms of the sentencing guidelines?
Yes.
Yes, the sentencing guidelines.
Yes.
The
state wishes to make an application in terms of section 50 of Money Laundering and Proceeds of Crime Act, chapter 24.31.
Yes.
Yeah, which deals with conviction-based forfeiture.
Yes.
The state will make the proper application in terms of that act as part of the sentencing procedure. Yes, our investigations have since been completed in terms of that act. So maybe I think that will also be taken into consideration in addition to victim impact assessment considerations in relation to that SI. So I don't know which dates could be appropriate for my learned colleagues, maybe next week. Can we see next week? My colleagues suggest that maybe the Wednesday, the 29th. I don't see another case which has been set
Wednesday,
before.
29th.
Yes, I don't see another case which has been set before His Lordship during that week. A criminal case.
29. So you intend to do that on the 29th?
Yes.
Which is when? How long? Today is the 20.
Today is when it's a Wednesday. Next Wednesday.
Oh, next Wednesday.
Yes.
Any problems, Mr.
My Lord, I wanted to understand, maybe my learned colleague would assist, whether his application is oral or it's in written form.
Oh, I
It
see.
would really help us.
Yes, Mr. Maduku. I said Mr. Maduku, Mr. Mabaudi.
Oh, Mr. Watuku.
No. You can see that I'm tired. I'm sorry to say when I meant you, Mr. Mabaudi.
Yes, my Lord, if there is, maybe what might happen is that the state will then decide to file what in writing, and then it will then motivate. And my colleagues are entitled to, accused persons are entitled to respond to the application as well. So I think so. The state is the state is talking about money laundering.
Sorry. So you will decide. Let me say, if you decide to do it in writing, do it early enough to allow the accused persons to respond.
To respond, yes.
Yes.
Indeed.
And if there are any documents that you intend to produce, please save them well ahead of time.
Indeed.
Yes. Just for the, before we rise, just for the record, when I turned over this page, I realized that there's a paragraph which I did not read when I was referring to coincidences, which is on the record. I said, is it a coincidence that the accused, the Militech then participated after being appointed an agent, and this paragraph continues, would it be a coincidence that after receiving the money was quickly disbursed to Militech Investments, which dealt with the money in exactly the same way the first accused company dealt with. It was immediately withdrawn. It was then traded on the black market, for example, and the amount which was raised was not recorded, and there is no explanation as to how much money was spent on the goods and no record of it. And there's also no record of the goats which Militech supplied. We find that that was not a coincidence, but that they were of like mind. I'd omitted to read that. I'm sorry about
that. As the court places, my lord. My lord, I don't know if we can then revert to the issue that my learned colleague had then made submissions on. My lord, I wanted to submit that I think if my brother should be clear, if he's filing it in writing, he must be clear that he's decided to file it in writing, so that we have clear notice. And also, I would also submit that without really defining what time he should file well in advance, he can file a day before, would be entitled to adequate notice.
Maybe let us just agree on time frames, isn't it? That if the state intends to file something, they must do so by a certain date. Mr. Duku, you want to
Yes,
weigh?
I have something to say, my lord and learned assessors. Our problem for the second accused is that my learned friend has announced that he wants to proceed in terms of two laws, the sentencing guidelines and the money laundering. We think that there will be two stages. We do not believe that the money laundering act will apply or would arise.
At this stage?
At this stage, yes. It cannot. So if he wants to deal with the money laundering, then we must clear it first and see whether or not it will arise, whether it is relevant. Otherwise, our attitude with respect to my lord and learned assessors is that we just are bound by the sentencing guidelines. There is a conviction, we go by the sentencing guidelines. If there is room within the sentencing guidelines for the application of the money laundering law or regulation, then it must fit within that scheme. So we wish to put on record that we take that as a very important position as to the sentencing stage and the bringing in of the Money Laundering Act. So if there are going to be guidelines, we would suggest my lord and my learned assessors that my learned friend clears the way. Let's be clear and the ruling made as to how does he bring in this animal money laundering.
I am not prepared for this, but let me just quickly refer to that act and just refresh my memory on what it says.
Maybe I could be of assistance, my lord. In fact, the Act requires that my learned colleague must obtain the leave of the court to make such application. And if he obtains the leave of the court to make such application, he has the right to then make the application within 6 months. And it is an independent application which he can lodge within the prescribed time. In particular regards, my lord, I refer to section 50 subsection 2 of the Act that my learned colleague has referred to, which says he must obtain that leave. So he has not even made an application to have the leave to make that application in the very first place. So I would submit that that is a completely separate proceeding. If he so chooses, he must first obtain the leave of the court. And after he obtains the leave of the court, then he can then...
I hear you and tend to be persuaded when you say it's an application is separate to a criminal trial, and which is made in terms of section 50. In other words, it is not part of proceedings at a criminal trial. That prima facie, I'm convinced by that. I'm persuaded. I will allow the state to speak. But where I don't agree with you is that if that application has to be filed, then leave of the court is invariably required. Is it not when it has not been made within 6 months, then that's when leave is required? Which means that we can complete these proceedings whenever we are going to complete them, and then the state can immediately file. It says within what? With 6 months. Oh, within 6 months of the date on which the person was convicted. Maybe the mischief which the state is trying to deal with is What if they're convicted now and they're sentenced after 6 months? But I don't think that will arise anyway. No court would delay a sentence for too long. Yes, no sentence would do that. Mr. Mabaude, are you not persuaded that an application is exactly what it says? It is an application that must be commenced in terms of the rules of the court. And ordinarily applications, unless they are part of a proceeding, they are made in writing. They are commenced in writing.
My lawyer says the state does not really want to commit itself at 7 p.m. On that point. Maybe we could sleep over it.
Yeah, you can then sleep over it, and then what do? We convene again tomorrow. Because you want to be guided as to what is going to happen before the. You have agreed on the 29th, isn't it?
Yes, the 29th.
Maleta, they had problems with the 29th.
Oh.
I wanted to suggest that I wanted to propose that we proceed maybe tomorrow or on Friday.
To do what? To
proceed
comply with
the state has said they want to
procedures
sleep
in the
over it.
Senate.
Yes. I would expect that maybe if they sleep over it.
Well, we can give the state up to Friday to indicate how they are going to proceed, whether they are going to proceed. But in terms of complying with the requirements of the citizen guidelines, to Friday would be too soon, because there are, the usual victim impact statements and so on and so on, which require a bit of time. So the 29th will be fine, unless you are not available.
Indeed,
You are not available.
I'm
Can you
not
agree on
available.
another date then?
I would suggest, subject to my brother's diaries, I'm available on the 3rd, 4th, and 5th.
Third.
Yes.
Which two? What day of the week is it? You can't agree on an earlier date. November would be too far. And November usually gives problems because the last month of the term usually gives problems because all cases that we are postponing, we are picking them already in November.
Maybe the 31st.
31st is a Wednesday.
It's a Friday, my lord.
It's available. It's available.
Yes, we can open it.
So that will be the date for mitigation and aggravation. So let's just call it pre-trial, pre-sentencing inquiry. Yes. No. Then the date of sentence will be announced on that day. Yes. Anything else? At what time? 11.
At 11.
The court will rise.
My task.